Moderating our first panel today is the Honorable Rashad A. Howder, a North Carolina District Court judge in Wake County. Judge Howder is a graduate of Campbell University School of Law and the University of North Carolina at Chapel Hill. He was appointed to the bench in 2021 and was elected to a full term in 2022. Judge Howder is the first Yemeni American judge in the United States and the first Muslim American judge in North Carolina. Recently, he was appointed by Senator Phil Berger, the President Pro Tem of the North Carolina Senate, to serve on the Judicial Standards Commission. But prior to his judgeship, Judge Howder served as an assistant district attorney, a statewide resource prosecutor, and an attorney in private practice. Please join me in welcoming Judge Howder.
Good morning, everyone. It's great to be here. We've got a great panel lined up on a very relevant and recent issue on DEI in the courts. The panel will discuss legal developments in regards to diversity, equity, and inclusion in North Carolina and nationally as it relates to higher education, particularly with the recent Supreme Court decision from last year, Students for Fair Admissions versus Harvard and versus UNC, and the broader implications that it's had on employment, both private and public higher education, municipalities, internships, and different fellowships that may be offered by law firms and employers. I'm going to briefly introduce the panelists. I had the opportunity to read so much about each of them. They are very distinguished in this field and experts in this field. Stephen Cox represents business clients in the litigation and arbitration of complex commercial matters, focusing on construction, employment, and corporate governance disputes. Admitted to practice in North Carolina and South Carolina, he has represented parties in numerous class actions and derivative actions and has significant experience in both states' business courts. Stephen has appeared before the U.S. Court of Appeals for the Fourth Circuit and the U.S. Supreme Court. He has handled numerous arbitrations before JAMS, the American Arbitration Association, and the Financial Industry Regulatory Authority, and he regularly serves as an arbitrator and mediator himself. Stephen represents a national chemical supplier in a case of first impression, North Carolina, involving the application of the UCC's good faith pricing standard to a multi-million-dollar chemical requirements contract. He was also on the Bradshaw team engaged to defend an international shipping firm in an action where the trial court had already certified a class seeking over $100 million in damages and denied summary judgment. Stephen and the firm's lawyers successfully petitioned for decertification of the class, a decision that led to the end of the litigation. Stephen serves on Bradshaw's board of directors. Gilbert Dickey is a partner at Consovoy and McCarthy. Mr. Dickey represents clients in trial and appellate courts with a focus on constitutional issues and complex litigation. He has argued multiple times in both federal and state appellate courts. He has also served as lead counsel in high-profile challenges to state law. Recently, Mr. Dickey served as court-assigned amicus in the U.S. Court of Appeals for the Fourth Circuit to present a novel challenge to Article III jurisdiction to enforce agency orders. Mr. Dickey has litigated several challenges to racial classifications following the Students for Fair Admissions decisions. And perhaps most notably, he argued the Fearless Fund case, where the 11th Circuit held that a racially exclusive small business grant was impermissible. Before joining Consovoy McCarthy, Mr. Dickey worked at a major international firm where he was elected partner. He also served as an associate White House counsel. In that role, he assisted with the confirmation proceedings for Justice Amy Coney Barrett. Earlier in his career, Mr. Dickey was an assistant solicitor general in the West Virginia Attorney General's office, where he assisted with key appellate matters for the state and served as a lead trial counsel defending the state's right to work law. Mr. Dickey served as a law clerk to Justice Clarence Thomas of the U.S. Supreme Court and Judge William H. Pryor, Jr. of the U.S. Court of Appeals for the 11th Circuit. He graduated with honors from the University of Chicago School of Law, where he was selected to the Order of the Coif.
Could you have done more things?
He earned his BA magna cum laude from Samford University. Mr. Dickey is a member of the Virginia, Alabama, District of Columbia, North Carolina, and West Virginia bars, and he resides in Charlotte. Devon Westhill is the president and general counsel of the Center for Equal Opportunity. The mission of the Center for Equal Opportunity is to study, develop, and disseminate ideas that promote colorblind, equal opportunity, and non-discrimination in America. The center supports removing discrimination on the basis of race, sex, and other immutable characteristics, but opposes ideas that simply replace discriminating against individuals on the basis of skin color or ethnicity with granting preferences on those same bases. The center instead studies, develops, and disseminates ideas to promote colorblind, equal opportunity, and non-discrimination in America. Devon Westhill is an attorney focused on matters of constitutional and civil rights. He researches, speaks, and writes about civil rights, civil liberties, and related issues such as race relations, social change, and equal opportunity. Mr. Westhill's writing has been published in numerous outlets, including Newsweek, National Review, and the Wall Street Journal. He has spoken hundreds of times at college campuses, conferences, and on radio and TV programs, and he is frequently quoted in print publications such as the Washington Post. Mr. Westhill has also provided testimony to both houses of the U.S. Congress, the Equal Opportunity Commission, the U.S. Commission on Civil Rights, and as an expert witness in federal court. Immediately prior to his current position, Mr. Westhill led the Civil Rights Office at the U.S. Department of Agriculture in the Trump administration as Deputy Assistant Secretary for Civil Rights. He has also worked at the U.S. Department of Labor, Federalist Society, and as a criminal trial lawyer in private practice. Mr. Westhill is a U.S. Navy veteran with degrees from UNC Chapel Hill and the University of Florida. Please help me in welcoming the panelists. And so we're going to start off with opening remarks from each of the panelists on your personal experience in cases that you've dealt with, any cases that you've served as expert witnesses in, any best practices that you have advised clients on in the recency of these decisions, the SFFA case, the Novant case, and then Mr. Dickey, if you can go into some detail about the Fearless Fund case that you've been involved in. So if we can start off with Mr. Cox, and then we're going to open up the floor to any questions. If there's no immediate questions, I'm sure I've got plenty of questions to ask the panelists after the brief remarks. Mr. Cox.
Thank you for that, and thank you for the introduction, Judge Hunter. It reminded me that I need to update my bio to remove cases that I lost several years ago. But in any event, I approach these issues principally from the perspective of someone who practices employment law almost exclusively with respect to private employers. And for people like me, these cases that have been coming down in the past few years have generated a good bit of shifting sand. DE&I programs and policies have been around for a long time. In fact, they have their origins, I think, in the late 1960s after the passage of the 1964 Civil Rights Act, when a number of companies hired consultants, anti-discrimination consultants, to teach them how not to be sued under new laws that said race and sex discrimination was illegal under the 1964 Act. And those efforts, those consultancies grew over time. And by the middle of 2020, most big companies in America had established DE&I programs. They had established DE&I staff. They had established DE&I policies. This wasn't really a mystery to many folks. But then with the death of George Floyd in May of 2020, all of that sort of exploded. And folks like me started getting calls all the time from people who wanted to create and expand and fortify their DE&I programs. The position of diversity consultant or DE&I consultant proliferated like mushrooms after a rain. These issues were in discussion all the time, and we could not even keep up with the demand on DE&I policies and DE&I programs. Then the backlash started, and all of that culminated in the Supreme Court's college decisions in 2023. And suddenly people like me started getting calls from the same employers with different questions. What do I do now? What does this mean about the future of our DE&I programs and policies? Can you please take a look at my programs? In some cases, can you pare them back? In some cases, can you eliminate them entirely? These employers felt like they had been the victim of a profound case of whiplash, where it used to be you could do pretty much anything you wanted within the umbrella of DE&I, and now it seemed like you could do very little. So the general advice I give these employers, as a lawyer who counsels private employers, is to lightly paraphrase Mr. Twain and say the death of DE&I is exaggerated. Perhaps not greatly exaggerated, but it is exaggerated. There are a number of valuable programs and policies that were born by the DE&I movement, I'll call it, that remain valuable, useful tools for employers. And we need to identify those as lawyers. We need to retain those, and we need to counsel our clients how to use them properly and with minimizing the fear of liability or risk. But we have to be careful to separate those useful DE&I tools and policies and procedures from what a good friend and law partner of mine calls DE&I foolishness. And we have to make sure we don't throw the good DE&I babies out with the DE&I foolishness. So how do we distinguish between the two? Let me give you a couple of examples of each kind of program or policy I'm talking about. When I came to North Carolina from my hometown in South Carolina 30 years ago to find a job as a lawyer, a number of law firms in this state did not have what I'll call a consistent set of interview practices. If you grew up in Greensboro and you went to Chapel Hill and you played golf with a single-digit handicap and you went to the same fraternity as two of the members of the recruiting committee who were interviewing you, you had a pretty good, easy interview. Something along the lines of, how's your mama doing? If, on the other hand, you were a white guy who came down to North Carolina from Long Island and you had gone to Fordham and you didn't know what a fraternity was and you couldn't distinguish between an Eagle and the back nine, you had a very different kind of interview. Not hostile, not adversarial, just different. It was a reflection of the sort of common sense observation that the interview differed, sometimes significantly, based on the comfort the interviewer felt with the interviewee. There's nothing magical or complicated about that. That's human nature. But over time, employers started to realize that's not a particularly effective way of identifying and retaining good talent for the job you're trying to fill. We need to put rigor and thoughtfulness into our interview questions, and we need to make sure we apply those questions to everybody, regardless of what their demographic characteristics may be, where they come from, or how they play golf. That's a good thing. It was overdue, and we counsel employers to retain that practice. One other good practice that we counsel employers to retain is getting the biggest pipeline possible. What's that old joke they used to say around these parts when I was growing up about the fellow who said he listened to both kinds of music, country and Western? Back in the day, 30 years ago, some of those same law firms said they hired from both law schools, Duke and Chapel Hill. And then people came to realize that if you really want to assemble the broadest pool of talent possible, you need to go wherever the talent is, and talent can be anywhere. So people started to become much more aggressive and thoughtful about interviewing at colleges they'd never been to before, going to law schools they'd never been to before. In cases where they were trying to recruit and retain talent that did not need a college degree, they were tapping into community organizations, professional organizations, finding ways to reach people wherever they were. That's a good thing. That's something we need to retain. Expanding the pipeline, making sure we interview all of our potential talent the same way, ask the same questions to the same people, regardless of the color of their skin or where they come from or what their religion is. That's a good thing. That came out of the DE&I movement, I'll call it, and we need to hang on to that. But what are some examples of some DE&I foolishness? Remember I told you a moment ago about these diversity consultants. There's a case out in Seattle that's perhaps one of the best illustrations of this, in which a fellow who worked for the city of Seattle quit his job and filed a constructive discharge and hostile work environment case against the city. And he based that in large measure on some of the diversity training he was required to participate in as part of his job, in which, among other things, the non-lawyer diversity consultants who were running the training said that all white folks were racist, white people are devils, and they concluded the exercise by playing what they called white privilege bingo, which I thought was kind of funny, but is probably illegal. In any event, he cited that as evidence of a hostile work environment, and the district court refused to throw it out. Because not only did all of that take place in the training the trainers sort of jumped off of that, springboarded off of that, and started directing a stream of insults and taunts to this fellow personally based on the training he had participated in. That's a classic example of what we call D&I foolishness. I would encourage you to Google United Airlines, Coke, and Disney, and DE&I together. Not right now, unless we're really not doing a good job, but whenever you get out of here. And if you do that, you will find similar stories where you just, as a lawyer, you're just holding your head in your hands saying, how does this possibly happen? Well, the way it happens is a company who's in charge of running D&I training or launching a DE&I exercise hires a consultant, almost always not a lawyer, and then does not make sure that the in-house legal department, at a minimum, if not an outside law firm, is reviewing the materials that these diversity consultants are planning to put in front of the employees. In fact, in my experience, in many cases, the in-house lawyers who are in charge of keeping the company away from legal risks don't even know that the programs are taking place, much less what's being told these employees, even when the programs are widespread and vigorously implemented. Now, let me end this one point by saying, not all such DE&I training is bad. We're going to talk in a moment, I think, about the next wave of lawsuits, and I think DE&I training is fertile ground for the next wave of lawsuits in this area. But there's another case from the Second Circuit, a Honeywell case involving Honeywell, in which Honeywell was implementing something called unconscious bias training online, and they required their employees to watch it online and certified that they had watched it. One of the employees got very upset and said there was no way he was going to watch it. He refused to be called a racist. Time and again, the company asked him to participate in the training, and time and again he said no, and he was ultimately terminated. He sued, and the district court and later the circuit court threw out his suit, saying that he did not have an objectively reasonable basis for thinking that he was resisting racially discriminatory conduct because he never looked at it. He never opened up the link and looked at it. And in fact, his coworkers told him that it was a balanced presentation involving white folk and black folk. And if he hadn't even looked at it, the court said, you cannot possibly think that you were being retaliated against for resisting it. So that's just, I make that point only because I don't want to suggest that no diversity training is acceptable, but you have to tread with caution. And in particular, you have to pay careful attention to these diversity consultants I spoke about earlier. One more example of what I'll call DE&I foolishness. I think even before the college admission cases, anybody who's an employment lawyer would have said, the law does not allow you to have a quota by which you reserve a certain number of positions in your company for people of a certain race or gender. That is illegal, pretty clearly illegal. Now, you probably know about the Weber case and the Johnson Transportation case back in the day, early Supreme Court cases, later codified in EEOC regulations that say a temporary affirmative action program is okay if it is narrowly tailored to remedy a particular long-standing imbalance with data and statistics to back it up, and it has to go away once that imbalance has been addressed. It can't hang around forever. But a long-standing general quota system for employees, which is what the court thought was going on in the Novant case and some of the other cases, is not permitted. So having given two examples of what's good and we should hang on to, and two examples of DE&I foolishness, let me close by giving one example of something that I think is in the middle. I think it's still the law that a company is free to have a mission statement or a policy statement that says, we are committed to a diverse and inclusive workforce. That's always been okay. There are lots of court cases saying that's okay. It's a little bit in question now. Can that statement go one step further? I'd be really interested in what my colleagues on this panel have to say about this and say, we want that diverse and inclusive workforce to mirror the communities we serve. You're getting into more dangerous territory there. But what if you go one step beyond that and you measure the makeup of your workforce with demographic statistics? You maintain statistics saying this is how many women we have, this is how many black employees we have, how many Hispanic employees we have. And what if you review that data regularly? There's some older cases out there that suggest that just maintaining the data, maintaining demographic statistics on your workforce is okay. But as we saw from the Novant case, from the De Benedetto case in Georgia, if the courts think you're using that generalized demographic data to drive individual employment decisions, to decrease your percentage of white employees, for example, or increase your percentage of women, you're going to be in trouble. So what I'm counseling employers these days who really want to maintain demographic data is, why are you doing that? What purpose are you serving? And isn't there a great danger that one of your employees may take that data and turn it to ends that are inappropriate? So to conclude, there's still lots from the DEI movement that I think is helpful and that can help employers maximize their ability to find, recruit, and retain really good employees of whatever demographic profile. But you have to be careful, and courts are certainly scrutinizing what we've come to call DEI foolishness. Thank you.
Thank you, Mr. Cox. Mr. Dickey.
Thank you, Judge Halder, and thank you to the Federalist Society for putting this program on and for all of you for being here. I will say I've read my bio, but hearing it out loud, I really had a problem keeping a job early in my career. Did not realize that till now. So this DEI in the courts is a pretty broad topic, so I want to just touch on sort of three different areas where we've seen substantial litigation briefly. The first, and maybe sort of the elephant in the room, is, of course, in admissions in higher education. We got the Students for Fair Admissions decisions a couple years ago now. Those are the decisions where the Supreme Court held that racial consideration of race in admissions to college is unlawful. It was a challenge to the admissions programs at UNC and Harvard. Full disclosure, that was the first case my firm, Consovoy McCarthy, ever brought when we were opened. It was really the brainchild of one of the founding partners, Will Consovoy, who unfortunately passed away shortly before those opinions came out. But we were ultimately able to prevail there. And I think people generally understand that the import of those decisions is, for the vast majority of universities, no more consideration of race in admissions. I say the vast majority because there was a footnote reserving whether there was some particular interest that could be advanced by the military academies that would allow them to continue to consider race in admissions. Again, my firm has sued both West Point and the Naval Academy to challenge their use of race. Those cases are moving pretty quickly. The Naval Academy trial just ended last month. So we may hear more on an answer to that, both from the district court and, as relevant here, potentially the Fourth Circuit soon. And one other development there that's maybe relevant since we're here, and it involved Duke, the plaintiff organization in the cases at the Supreme Court recently sent letters to both Duke and Princeton. Both universities had filed briefs in the cases at the Supreme Court saying, we're not going to be able to maintain our same racial numbers if we are told we can't consider race in our admissions process. We've seen a substantial increase at most selective universities of the number of Asian Americans admitted after the Harvard and UNC decisions. But I believe the numbers actually went down at both Princeton and Duke. And so SFFA sent both letters sort of warning them that they need to make sure they are complying with the law on the consideration of race in admissions. But I gather the primary topic for today is sort of private sector stuff. On this, I think there actually might be some agreement between me and Mr. Cox, and perhaps some disagreement too. One thing I want to highlight at the beginning is Students for Fair Admissions does not have much direct application here. It was an equal protection case predominantly, also Title VI, but the exceptions for racial discrimination in admissions had always been sort of a weird one-off exception that was allowed by the Supreme Court's case law. Since Title VII and perhaps Section 1981 with the Reconstruction Congress, corporations have not been allowed to, or employers generally have not been allowed to discriminate in employment. And that includes when race is just one part of the motive. So nothing about the SFFA decision changed that. I think it's sort of a historically peculiar point that despite that fact, we did see an explosion of sort of a new wave of diversity activity at a lot of employers shortly before the SFFA decision came out. And I mean, if you had to put the over-under on when a DEI office was created at any business, I think 2015 to 17 would be a pretty good guess. a lot of these organizations, they get there and, they're setting goals and various things like that. And they start, tracking data, and they'll also issue these reports saying, and like, we don't want to just track anymore. This was a thing that was very much happening. We don't want to just track. We want to take action and have concrete goals and reach those. I think I would agree that to the extent what these offices, going back perhaps to the 60s, is doing, well, I would agree, is eliminating existing discrimination. That is entirely permissible and good. Nobody should be being discriminated against on the basis of their race. But we saw what some of these programs were doing was creating incentives for hiring managers based on the racial makeup of their team and things like that. That was always unlawful. That was unlawful before the Students for Fair Admissions case. I think where you get into the weird middle ground is, I think I would agree that, a company can set whatever goals it wants. It can have aspirations. It can track data. But there's a thin line between a goal and an intent. And so while they can do that, I think intent is always sort of what your motive was is always an issue in these cases. And so when you say something like, we want our workforce to look racially exactly like the community that we're working in, and then you maybe take some employment actions against employers, and lo and behold, at the end of those actions, your workforce looks a lot more like the racial makeup of the community that you were saying you wanted to mirror. I think that's a pretty decent prima facie case that race was at least one thing you were considering there. So it's not that the activity itself is prohibited, but, if you say your goal is to do something, I think an average person would say they can reasonably infer that means you would like to do that thing. And maybe if you act in a way that gets you there, that you meant to do that. And the third category I want to talk about is sort of these set-asides. And this is where the Fearless Fund case that I argued in the 11th Circuit comes in. And this was also done often by these sort of corporate DEI offices, where they would create these sort of grant programs, often for outside groups, saying, $20,000 for funding for a small business, but only if it's run by a Black person, or, name the race. They often had a variety of different ones, and also fellowships that were provided only to certain racial groups. On these, I think we haven't seen things really getting into the same sort of factual inquiry about well, you said this was your goal, was it your intent? For the simple reason that they were explicitly racially discriminatory. For example, in the Fearless Fund case, which recently settled after the 11th Circuit held that we were entitled to a preliminary injunction, the program was limited only to small businesses operated by Black women. And because these are sort of explicitly racially discriminatory programs, that's prohibited by Section 1981. I think we've actually seen more of the aggressive legal arguments on this side. So far, I haven't seen any of those being successful. I think probably Fearless Fund is the leading circuit court case post SFFA on one of these. I want to highlight two or three of the arguments they did raise quickly. One is the remedial program argument that Mr. Cox referred to, where under Weber and Johnson, they said that companies could have a remedial program to remedy past discrimination. I think this is one area where I think there's a real question post Students for Fair Admissions about whether that exception can still stand. If you look at a lot of the reasoning, and also, Gratz said the same standard applies to 1981 as applies to equal protection, then I think these are highly questionable precedents. Now, that being said, they really didn't get resolved in the Fearless Fund case, and for the simple reason that there are limits on the program, and it's hard to argue that when you're just providing a grant generally to remedy. A lot of the pre-existing case law is pretty clear that this is not about general societal discrimination that you're remedying. And so that was one problem. But what the 11th Circuit said is, it's always been very clear from this case law that what you cannot have is a total racial bar where 100% of these opportunities are going only to people of a particular race. That's what these programs do, so there really wasn't occasion to revisit the status of those programs after Students for Fair Admission. The other argument that they raised was that this was protected by the First Amendment, that they were trying to send a message about support for Black women and the businesses owned by them. I think the major problem this ran into is that the Supreme Court has several times said that, people can say what they want and deliver whatever message they want, but the actual act of discriminating by race is not protected by the First Amendment. I think a secondary problem here that the 11th Circuit kind of highlighted, or at least a related problem, was they never really came up with a good way to distinguish the things that are very clearly and have long been prohibited as like mine run violations of civil rights law would not also be protected by the First Amendment. In fact, the 11th Circuit opinion sort of goes out of its way to say, if that were right, it would be a peculiar world because the more blatant somebody is racially discriminating, the more protected it would be. And so it used an example of, if you had an owner of a reasonably large business with a diverse workforce who came in one day, fired every Black employee and kept all the white employees, you would probably have a good guess what they thought about equality in the workplace. That is not protected by the First Amendment, though. So those were the main arguments. There was a bit of a side argument there, mostly raised by amici, that under Section 1981, which is a Reconstruction era statute that says all persons are entitled to the same right to contract as white persons, that sort of set a floor, and that other people of other races could have perhaps greater rights to contract. This argument struck me as kind of peculiar. The 11th Circuit didn't ultimately have to address it. It's foreclosed by Supreme Court precedent anyway. But one of the peculiar things about it is people seem to think this is the stronger textual argument. But I've tried to come up with various ways to phrase that. I think we can summarize our position by saying same means same, not more than, not less than. I have not come up with a way to phrase the other position without adding words to the statute. Like, they appear to read same to mean at least the same or the same or greater than. But nonetheless, they seem to think that they're clearly right on the statutory text, which always struck me as a little peculiar. But I'll leave it at that. And ultimately, the 11th Circuit did agree with us on that one, and leave it at that.
All right, thank you, Mr. Dickey. Mr. Westhill.
Well, thank you so much. Can you hear me? So great to be here with you. As the judge was commenting, I've spent a fair amount of time in North Carolina. I really love this state. I'm a native Florida man. I'm back there again. And I've had to escape the hurricane this week, but made it in one piece, and I'm happy to be here. But I spent some time west of here at Chapel Hill, and so to some extent, I feel like I'm in a room of friends, but I'm in sort of like enemy territory because I've said a lot of bad things about my alma mater since graduating from there in the context of the Students for Fair Admissions cases. But I really have been saying good things about the University of North Carolina at Chapel Hill since the decision came down. It's one of the schools that really has done a 180-degree pivot away from what it sunk millions of dollars and years of time into litigating against, and it's turning over a new leaf in terms of equality of opportunity. And I think that's really important. I can be really quick in my remarks here. I want to talk about K through 12 litigation. I want to be quick. It doesn't mean that I will be, but I want to be in part because it won't take very long, but I really want to hear from the audience, and we'll have some time for questions and to respond to comments that you have, because there's so much going on in the post-SFFA space that we may actually not touch on any of the things that you actually are interested in. Before I get into the K through 12, I did want to just respond to some comments that my co-panelists made. Mr. Cox suggested that there's some good DEI and there's some bad DEI. I mostly agree with that. I think we have to be in this space after SFFA in dealing with DEI. We need to be specific about what it is we oppose. I think that's really critical because there are people who are sort of just twisting in the wind right now, who don't make it their business to know the ins and outs about DEI and race discrimination and where the lines are and so forth. It's incumbent upon us to make sure that we're explaining and being persuasive about what the worst of DEI is and where the good stuff is, because there is good stuff. And then there's also stuff sort of in between that, we might roll our eyes at or sigh and shrug and say, this isn't really doing any good, but it's not illegal. It's not immoral. And businesses and schools and so forth should be free to experiment in this space. And so we need to be careful about that, because if we are, I think we can persuade a lot of people who are in the middle, who think there's something that needs to be done to provide additional opportunity for disadvantaged people, don't like the worst of DEI, but who we can turn off to our perspective if we're not careful. Although I do quibble a little bit with the idea that doing something like casting a wider net for recruiting purposes and so forth really is something that came from what I call the DEI enterprise. DEI, in my view, that idea, casting a wider net and so forth, really came on the heels of the civil rights movements of the 1950s and 1960s to provide greater opportunity for people. There was a recognition among the public that we really did have this, old boys club and so forth. We needed to cast a wider net if we're going to actually benefit from people's different perspectives and experiences and so forth, and strengthen our teams and workplaces and on campuses. The DEI enterprise, that industry, it is a multi-billion-dollar industry that promotes a far-left ideological orthodoxy related to demographical relations and justice in society. That industry, that enterprise, I like to make sure that I'm distinguishing from true diversity, true equality of opportunity, true inclusion, views problems and solutions as influenced by or related to race, gender, sexuality, and other faddish diversity metrics. That is not where the idea of casting a wider net and true inclusion, bringing people in to workplace and so forth, on a more equal footing came from, in my view. In any event, I wanted to talk about K through 12 education litigation efforts, and I wanted to do so in the context of really what the Pacific Legal Foundation is doing to push back against what they view as, and my organization, Center for Equal Opportunity, supports and views as proxy discrimination in K through 12 admissions. So the number one magnet school in the country at one point was Thomas Jefferson High School for Science and Technology in Northern Virginia in Fairfax County. In 2020, for some reason, I leave it up to you to think this through, they decided to change their admissions program. Why would they do that? Why would they change their admissions program? They're the number one school in the country for science and technology, for instructing gifted students in this space. Why would they tinker with something, right, that ain't broke? The problem was, this was right after the George Floyd murder in 2020, and 73% of the student body that was admitted that was currently at the school was Asian. And that could not continue based on what school board members wanted at TJ. They were caught, it came out during discovery, they were caught writing about how this was intentful action to change the admissions program to make sure that there were less Asian Americans being admitted to the school and more of sort of preferred racial minorities, Black students and Hispanic students, to quote, address underrepresentation of Black and Hispanics, and change the admissions, quote, towards greater equity, clearly distinguished from equality. Again, remember that E and DEI enterprise is equity, not equality, and there is a big difference there. So what the school did was a couple of things. One was to eliminate testing. Another was to guarantee admission to 1.5% of the top 1.5 of more schools in the Fairfax County area. The big thing here is that this was not, race was not an overt factor that was used in making a change to the admissions program. And it was therefore seen as quote unquote race neutral plan. There's a lawsuit by the Pacific Legal Foundation. Trial judge did a great job here in seeing right through this and wrote in his opinion, quote, "Everybody knows the policy is not race neutral. It's designed to affect the racial composition." The Fairfax County School Board lost at the trial court level, but it was appealed to the Fourth Circuit. And the Fourth Circuit reasoned that because, I'm sorry, after the new admissions plan went into place in 2020, the following year, the composition of Asians that were admitted to the to Thomas Jefferson High School went from 73% to 54%. So the intent behind this to lower the number of Asian Americans to make room for others actually was successful. The Fourth Circuit suggested that Asians enrolled still had, still was higher than the local population essentially, and that therefore there was no discrimination there. But of course, and this is the Pacific Legal Foundation's position of my organization, the Constitution protects individuals from race discrimination and not racial groups. Now, all of this was occurring before the Students for Fair Admissions decision, and that makes sense too, as Gilbert was just suggesting. The Students for Fair Admissions decision does not directly touch on K through 12 education. There's never been a carve out for diversity like there was in higher education for K through 12. And this is something that we wrote about in our brief when this case went to the Supreme Court for certiorari review. What the school board wanted to do in terms of changing the admissions criteria is similar to the grandfather clauses in the South. What you knew they were doing was to intentionally gerrymander. They're intentionally trying to racially gerrymander the classes. The grandfather clauses in the South were doing the exact same things. This was the idea that, look, after the 15th Amendment, if you're Georgia or Alabama or whatever that had these clauses, if your grandfather was able to vote, you could vote without having to take a test to measure your competence. This was a way to ensure that blacks could not vote and that uneducated whites could still vote. It's the exact same, legally speaking, but the Supreme Court denied certiorari in the case. But I was very pleased to see that there was a stinging dissent from Justice Alito, joined by Justice Thomas, where in pertinent part they say, quote, "What we have here is with the Fourth Circuit is that intentional racial discrimination is constitutional so long as it's not too severe. This reasoning is indefensible and cries out for correction." Now, there's a lot of questions about why didn't they take the case then? What's the deal here? I don't have all the answers when it comes to that. What I do know is that there are quite a few other cases in the pipeline that the Pacific Legal Foundation is working on to get this issue before the Supreme Court. One is, it just goes by Boston Latin case, but I think it's called Boston Parent Coalition for Academic Excellence. I don't know why there's such strong, long names for these things. But anyway, Boston Latin, there's a case out of New York that has set up perfectly, which is nice, a circuit split between what the Fourth Circuit has held and therefore makes it more likely that the Supreme Court is going to take up this proxy discrimination issue in the K through 12 schools. And this is important sort of in the Students for Fair Admissions context in higher education as well, because there is a concern that proxies are being used to continue what the Supreme Court has prohibited race preferences in college admissions. We're getting reports from elite schools now, Harvard, Yale, MIT was the first to release their demographics for the class of 2028. And for some of them, their racial compositions aren't changing at all. Despite the fact, I think Mr. Gilbert mentioned this, despite the fact that Harvard went to the Supreme Court and argued without overt race preferences, we cannot keep our racial diversity the same. What happened? What changed in that period of time and is making it such that they can keep their numbers the same? There's some concern that proxies are being used to continue to racially discriminate in colleges and universities, and then of course in K through 12 schools. The last thing I wanted to say here is there are good non-legal counterpoints that bring additional difficulty to dealing with the proxy discrimination issue. One is that it's watered down, right? The public that has, and basically every poll and survey that I've seen in terms of overt race preferences and discrimination, the public is largely against, including majorities of racial minorities are against that type of thing. And this is kind of watered down, and it's easier to get past people. And also it doesn't have the stigma that's attached to racial preferences, right? You're sort of just discriminating in sort of a light way. That I think is a problem. And we have to think about how we sort of push back against proxy discrimination, notwithstanding what I think is a major concern for the public, that people ought not to carry for the rest of their career, like me, an asterisk on their resume because they're black or some other minority that went to the University of North Carolina or some other place that used strict racial preferences. Also, there's the idea that there's not the same sort of racial animosity that's created when using proxies, as opposed to race preferences. I think there's something to that as well, and also in using proxies such as SES status or getting rid of legacy, so that the real intent is to continue to admit more racial minorities. You are targeting, or at the very least, sweeping up those who are truly disadvantaged, and so. That there are some complications. It makes it more difficult than those cases that were very strictly, very obviously race discrimination in a very obvious way. And then finally, okay, and then I'll stop. I just want to personal for a second. What I think we ought to be doing as well in terms of trying to persuade the public, who again aren't very extreme on either side here, but are looking for more opportunity for folks, and is to say, at least in part, our country is changing all the time, and we are becoming incredibly multiracial, multi-ethnic, and this old school view of white and black and the box about Asian is really retro, and does not meet the present, and certainly not the future times. I have children now who, sort of racially, ethnically speaking, are white, black, and Vietnamese. Where do they go here in a world that looks at the boxes of white, black, Asian, Hispanic, what have you? I suspect that many of you have friends and family, and maybe yourself, multiracial, multi-ethnic, and so forth. We should be trying to persuade our fellow Americans that continuing to view the world through this racial lens is not the way we want to leave our country to our progeny. Thank you.
Thank you, Mr. Westhill. Folks in the audience, if y'all can come up to the microphone up here at the front for any comments or questions that you have for the panelists.
So that'd be quick, not Jerome.
And if you can just introduce yourself once you get up to the mic and go ahead with your question.
I'll pull up my notes here. Good morning, gentlemen. I appreciate the comments. This has all been extremely elucidating. I've really enjoyed listening to you. So I studied history. Sorry to introduce myself. My name is John Taylor from the town of Albemarle, North Carolina. I work for my family's law firm there, and I'm also a 1L law student at High Point University. It's getting off to a great start. If anyone's curious, having a blast over there. One question that I had is to consider like the historical perspective on this DEI topic. It does not take an extremely high level of historical acumen to trace the roots of DEI and see how it has been influenced over the years by critical race theory, originating from Derek Bell at Harvard University, and then going back to the Frankfurt School in Germany in the early part of the 20th century, and from there on back to Karl Marx. And so I think it's also clear to see that in Karl Marx, his ideology gave rise to communism, which led to the deaths of more than 100 million people over the past 100 years. I'm not saying that I personally, espouse these views, but some would argue that it is impossible to divorce DEI from its Marxist roots. And certainly I have no desire to be overly inflammatory, but I do think that this is an important question to ask. So given its historical roots, how would you say that should inform the element of caution with which we should approach DEI? And that, what do y'all think about that?
I was a medieval history major in college. My knowledge of history stops about 1250, so I'll leave that question to my two co-panelists.
I did more modern American history in college, so I guess dig back to, although I'm starting to get to the point where that degree is itself history. I'll speak as a lawyer, which is what I do most of the day now. I think a lot of the practices that we've seen are very much inconsistent with American law. I think the background is helpful, but not really something that is going to, I would not expect any of that to play a big role in sort of the litigation and the legal liability that people are facing as, we're advising about that. That goes more to the moral case for and against DEI. And to the extent we're talking about some of the dumber practices, I don't think you necessarily even need that background to appreciate that we should not be treating people differently on the basis of race.
I studied philosophy, so I'm really not qualified to opine here, but I will anyway because I'm a lawyer, but not even on the law. My thinking here is that I do see some real similarities that you've pointed out, and I think it's fair to say that you're sort of replacing workers and classes economically and so forth with race and other factors, and sort of dividing folks up as a result of that. And I think there are real similarities. I'm no expert there, but one thing I would say about that is I don't, from sort of my broader sort of point about persuasion and the court of public opinion, I don't know whether or not that is the best or one of the top three best ways to explain the problems of the DEI enterprise. I think some of the things that we've already discussed on this panel, and as Mr. Gilbert, Dickey just mentioned, we already have a lot of people who agree, race discrimination. So, this is all bad stuff. We have been sort of on the same page by and large in this country on those things. I think the DEI enterprise is an aberration. We ought not to, we ought to stay focused on what the worst of it is, and not to try to draw any parallels that might distract from what is very clearly problematic about it. But good thoughts.
Yeah,
Thank you, sir.
without speaking to the history, your question raises an important feature of what we're talking about up here, and it's something that Devon mentioned. We've been up here 45 minutes, so we're on a first-name basis now, which is talking about the DEI enterprise, for example, the DEI movement. It's often spoken of in these monolithic terms, right? That it is a movement and a history, and there's some truth, I think, to that in terms of historical progress. But when a client calls, and I've had these calls from clients before, some of y'all probably have too, a client calls and says something like, can I do DE&I in the workplace? Well, what does that mean exactly, right? So it's really important, I think Devon said this earlier, and Gilbert to some extent, that we be advertent to what's going on with D&I globally, both now and historically, but we also, when we're advising clients, urge our clients to be more specific. Because I do think there's a lot of agreement on the idea, look, you can't have racial quotas in the workplace, full stop. That's not a complicated point. But what about when it comes to these other practices that may be on the margins? It's really important to distinguish between what you're talking about, what specific practices are you talking about? Because only when we define the issue or the problem specifically can we give any sort of legal solution to it.
Thank you very much. I appreciate it.
If I could just briefly respond to this was something that I was thinking earlier in terms of like, we were talking about things that sort of broaden the net. And I think even there you can get into situations where you're worried about proxies, but I think there are sort of ways to do that. I think one of our arguments in the one of Students for Fair Admissions arguments at the Supreme Court was, you have all the very strong legacy preferences at a lot of these selective universities that are a pretty severe narrowing of the net, where you're not just racially, but sort of socioeconomically and all sorts of considerations. And a lot of the evidence was that they could accomplish their diversity goals writ large just by getting rid of those. And so, there are lots of things that are not even sort of really building in race that people could do sort of when you get into the specifics that might accomplish some of those goals they're saying they have.
Thank you. Yes, sir.
Thank you. My name is Tom Varicali from Belmont Abbey College. I am admittedly skeptical of DEI, and so my question is, to what extent are minorities still being discriminated against in the United States? Where is it coming from? And if such discrimination is not as common, why keep these DEI programs to begin with? Thank you very much.
Thank you.
Yeah. So first of all, I would say, and I get these newsletters from the Justice Department. Just sign up, and they'll send you notes about who they're suing and whatnot for these types, any sort of race discrimination against minorities that they can come up with. I don't think racial discrimination is gone in this world against minorities. I certainly think there's been a shift with the DEI enterprise, with affirmative action, and so forth, to provide preferences, in part to ameliorate the history of serious racial discrimination and oppression of minorities. But and that race discrimination is never going to go away. I don't think we certainly in no way have it like that today. That's for sure, and that's why I say sign up for the Justice Department's email newsletter, and you'll find out what they know and what they're trying to pursue. Now, I think what I see mostly with the Justice Department is suing on this disparate impact liability theory, that if the most recent one, for example, that I saw was with the Durham County firefighters. Fewer blacks were passing a test to become a firefighter than whites. The Justice Department determined it was too big a gap in terms of failure, and that as a result, under the disparate impact theory, there are too few black firefighters being hired. And the Durham Fire Department, the city of Durham, has now settled with the Justice Department. They're going to pay those failed test takers $1 million. They're going to have to hire those failed test takers, and they're going to have to change the test. I don't see that as discrimination, but the view of equity of outcome, not equality of opportunity, is embedded in this idea of DEI these days. It's something that I push back against, and it's the type of thing that is offered up. It was offered up in the dissents in the Students for Fair Admissions case as evidence of discrimination, that they're just socioeconomic disparities and other disparities that fall on racial lines. I think it's by and large different reasons than intentional discrimination, discriminatory treatment, but that's the answer that some people give.
I mean, I guess I'll say I think less than there was, but any instance of racial discrimination, less is not zero, and any instance of racial discrimination in any of these fields, be it employment, education, whatever, has been unlawful and remains unlawful.
Thank you. Yes, sir. Oh, I'm sorry. I know we had a mic on this side.
No worries. Yeah, I'm Connor Fraley. I'm a 3L at UNC School of Law, President Emeritus for the chapter over there. My question is primarily for Devon, but I'm happy to hear from kind of anybody. The Pacific legal cases, like the Coalition for TJ ones, the Boston Parent ones, they're kind of rooted in as basically Arlington Heights challenges. It's had a lot of workability issues. The petition for certiorari really pointed to some of the methodological problems and tried to find a split in methodology, like this before versus after approach. And part of the concern about that is any kind of policy might have a before and after effect. And yet, like they say that motive is the thing that makes a difference, but there's always just this reticence from the courts to really look at legislative motive in those ways. So my sense is there's going to be a lot of litigation there, but in terms of finding a workable standard that's actually going to do this, do you think that Arlington Heights is the right way to go in terms of dealing with what you're dubbing proxy discrimination?
Yeah, I mean, that's the vehicle that the Pacific Legal Foundation has chosen. So Arlington Heights case, for those who don't know, basically makes it possible for the Pacific Legal Foundation to go to sue the Fairfax County School Board and say, look, yes, we can't point to race discrimination here, but here are a number of factors that seem to suggest that that's occurring. One is, look, right after they announced this change in their admissions policy, Asian American enrollment went down like almost 20% or something like that. Here's another factor that seems to suggest that what they were really trying to do here was to racially discriminate. The multi-factor test, I think, is really what we have in our toolbox to use to try to deal with the proxy discrimination issue. I'm open to hearing, and hopefully you're writing about this. I'm hoping, I'd love to hear other ideas and how we try to get to, get these sorts of cases into court and to prove them. But right now, I think that's what we have, and that's what the Pacific Legal Foundation is using.
Hi, Ned Headley from the Hamilton Lincoln Law Institute. So this is more for Mr. Cox, but feel free, the whole panel. So really DEI kind of gained traction in the Bakke case and was really kind of just focused on higher education, but it seems to have expanded and bled into obviously the private sector. I'm more curious about your thoughts when you see federal judges kind of using it in terms of appointment of counsel and class action lawsuits and tracking those metrics. What are your thoughts about that? Because that seems like it's obviously, they have a lot more free reign as federal district judges and using these kind of metrics in terms of appointment of class counsel and things of that nature, which can be quite a lucrative assignment, and using that as a metric to make those types of decisions. Because I know you have some class action background. So what are your thoughts on that?
I do have some class action background. I can happily say I don't have experience on that issue, so I don't have an opportunity to criticize federal judges in this forum. So I really just can't speak to that issue, but my colleagues might be able to. That's what we call a hard pass. My apologies.
Hi, my name is Paul Behringer, graduated Alabama law last year and clerking on the State Court of Appeals here. I guess this is a question Mr. Dickey, you can probably answer to the fullest extent, but the post-SFFA litigation about that footnotes for the military academies, leaving open the door to consideration of race and gender. How do y'all see that litigation panning out at the risk of mixing metaphors? Will they abrogate? Do you think they'll abrogate the footnotes, cabinet to its facts, or Campbell's nose under the tent to rewind some of the reasoning in it? Just because their footnotes can control the outcome of opinion, but I'm sure Justice Breyer can quote chapter and verse on after Trinity Lutheran, there was a footnote allegedly cabining that to the facts of a playground, funding of a religious playground, and that got memory hold pretty quickly in the wake of it. So I just wanted to get y'all's thoughts on that.
I think I'm limited in what I can say because
of course.
my firm is involved in those lawsuits. I have not been on the team on those up to this point, but I mean, so I'll say this: Students for Fair Admissions was a case that applied strict scrutiny. In the context of that, they dropped the footnote saying that the military academies might have a particular interest that could justify their policies going forward. We sued to challenge their use of race and viewed that as largely the issue there, and we'll see what the courts do with it.
Fair enough.
My only thought about that is I don't see any way out for the service academies in terms of the reasoning that the court used in Students for Fair Admissions. I mean, some of the reasoning is just, you can't get it's logic games, right? You're like, look, you're in a closed system. There are only so many seats. It's a zero-sum game in admissions, and one of the twin commands from Bakke is, you can't use race in a negative manner. If you're giving a preference based on race to some student for admission to West Point because of their race, you're giving a negative to some other student or applicant to West Point because of their, some of that stuff. I don't know how the court is going to reason out of that because there's some sort of military exception that's unique to the service academies. I personally, I don't see it.
Good morning, Jason Strickland, former Martin clerk. He taught me to be trenchant, so we'll see if I learn anything. In North Carolina, as in many states, and also at the federal level, there's a pretty aggressive preference system in public construction contracting. In other words, if the government wants to build a building, it'll solicit bids, and one of the things it wants to see is how the contractor is going to spend a certain percentage of those dollars on minority-owned or women-owned contractors. If you look at the reasoning from the Students for Fair Admission cases, it would seem like that type of system is on pretty shaky grounds. So my question is there litigation on the horizon regarding those systems? And if litigation does come about, what are your thoughts on whether it can find some exception to survive or not?
That's a great question. I think shortly after the SFFA case came down, one of the first calls I got about it was not from a lawyer, not from a judge, but from a buddy of mine from my hometown in South Carolina. I didn't know people in Moncks Corner, South Carolina. I really closely followed Supreme Court jurisprudence, but he did. And he's a residential contractor. And in that particular area, there was a government program that favored, minority contracts, just as you've described. And we talked about it. It's an attorney-privileged conversation. But I will say this, I think those programs are at risk. I mean, there are lots of municipalities and counties that have those programs. They're pretty robust. There are lots of requirements that have to be fulfilled. And I think it's very challenging to square those programs with the language in those cases, not just the most recent cases, but other cases too. The one thing that the SFFA case has done is really shown a spotlight on lots of things that maybe people weren't paying a whole lot of attention to. That's one of them. And so I'm sure there are cases out there. I can't speak to one that's already been filed, but I'm sure there are cases out there in which someone soon is going to challenge those programs.
I think I would agree with most of that. So I would say that a lot of these sort of set-aside type programs were highly legally dubious before SFFA, but I think what we have seen is a renewed interest in enforcing these non-discrimination limits after SFFA. I believe there have been some challenges to sort of similar contracting set-asides in other places, but don't have any specific detailed knowledge on that, so I won't venture further than that. But I think, it was dubious before, and, there's a lot of risk there to the extent there's renewed interest in enforcement of non-discrimination now.
I have nothing to add. Perfect.
Thank you.
Thank you all for speaking here today. My name is Caleb Fisher. I'm a 2L at Campbell Law School and vice president of the Federalist Society there. I received a number of rejection letters my 1L year, but my favorite were the rejection for the diversity fellowship programs at different law firms in the area. I'm curious, Mr. Cox, if you think that falls into the good section of DEI, or if that is going to become an issue, and if I have a case. Thank you.
I'm sure Mr. Dickey's happy to represent you. We've already had that challenge, right? Marston, Foster, and Perkins Coie, aren't they the two firms that were challenged? I'm sorry?
Winston and Strawn.
Yeah,
also.
and characterize it. You're exactly right. I have a friend of mine at another firm who shall remain nameless, and he said his son was a 1L and called a prominent law firm somewhere in the southeastern United States and asked about getting a 1L job. And the hiring coordinator for the firm said, well, we only hire 1Ls if they're black or women. And I thought, good Lord. Even if that's what you're doing, good Lord. So, and then now there've been some challenges. I think a number of law firms are revamping their diversity clerkship programs. A number of law firms still have diversity clerkship programs, and they're revamping them to make it clear that diversity means lots of different things, not just race or gender, but they will also give consideration, for example, to whether someone's from rural America versus urban America, or that sort of thing, to try to bring it more in line. But your question, and the answer your question points to is, I think, pretty straightforward, that if you had a diversity clerkship program that reserved spaces for people on the basis of race or gender, it's hard to say that could pass muster. Gilbert, do you agree?
Yeah, those suits against the law firms were also brought by my firm, Consovoy McCarthy. So, and most of those settled pretty quickly because they were explicit set-asides, and, you have sophisticated lawyers who see a sophisticated set-aside, so they settled. There are a lot of other programs out there. I think the devil is in the details of the extent to which it is, actually a set-aside or something close, and to the extent, it's phrased in different ways, but it's really discriminating or putting the thumb on the scale based on impermissible factors. So it takes a little more assessment of the particular one, but certainly you can't have a more generally phrased one if you're still, then taking action based on race.
I just want to say, can we just take a second to sort of be aghast at the legal profession that was doing something like that? And to the extent that they're now being forced by Consovoy and McCarthy and no one else, I guess, to change their ways, that hopefully they really are doing that. One of my concerns is that the DEI enterprise is sort of, and I've read some articles, from DEI practitioners and so forth, that suggest, well, we just sort of like change the name, like DEI has gotten a bad rap and let's change it to belonging or, whatever, and keep doing the same thing. To the extent that that's happening, we need to be diligent. And continuing to look at not only these colleges and universities, these workplaces and so forth, but like to the legal profession itself, doing these types of things to those students who we're trying to bring into the legal profession. Then the last thing I'll just say generally about the DEI stuff and fellowships and merit and so forth is what Caleb didn't say was that he's been a fellow in the Center for Equal Opportunities Summer Civil Rights Fellowship. We bring law students from around the country every year to Washington, D.C. to train under the best conservative civil rights lawyers and policymakers and so forth, and try to share with them ideas that they're unlikely to hear on those topics in their classrooms. And Caleb is one of our stars. But what we've learned, this is just sort of anecdotally, but I think those folks who are trying to think about how they change their DEI should be thinking about this as well. We pick those students on merit. Not because they're LGBTQ or because they're a certain race or women or whatever. But oftentimes, we have incredibly diverse classes of fellows. I think, when you prioritize diversity in this really shallow way, you end up losing merit. You prioritize merit, you oftentimes get diversity in those faddish ways as well. So prioritize merit, prioritize treating people as individuals. I don't know why I need to say this, judge people by the character, the content of their character, not the color of their skin, but you're likely to get those things anyway. We've had LGBTQ students in our fellowship. We've had all sorts of races, immigrants and so forth. If we begin to shift our focus here when thinking about DEI in a true diversity sort of context, we're likely to get all the other things that folks have been discriminating against people to get anyway.
Got time for a couple more questions. Good morning. My name is Justin Booker. I'm the president of the Federalist Society at Campbell Law School. I'm glad that Caleb teed up my question here because mine is very much related. In learning about Students for Fair Admissions, one of our constitutional law professors at Campbell has written the School Career Center to inquire if these diversity, equity, inclusion clerkships and scholarships would also accept white applicants. And if they don't, why is the school advertising these things? Because quite frankly, we're inundated with these throughout the school-wide email blasts. And is it a further violation of Students for Fair Admissions if the school is promoting those further than the clerkships and the internships and the scholarships are giving them out?
I'll confess I have, obviously we challenge some of those programs. I have looked at the programs themselves. I don't know that I've ever given much thought to whether, the promotional email being forwarded by the school would itself be some sort of legal violation. So being uninformed, I'll defer, but it's an interesting question.
To be clear, what Students for Fair Admissions, gave us was prohibition on the use of race in admissions. Now, it gave us a whole bunch of other sort of fun dicta and so forth as well. And also the opportunity as a result of that to test the boundaries of what it might mean, it might hold in that the lovely four corners of that decision. So I'm actually not sure as well. We purport to be experts on this subject, but I'm not exactly sure. I think we are going to see, though, because of things like that and other DEI practices and so forth on college and university campuses, is litigation testing to see just how far the boundaries of SFFA goes. And I wouldn't be surprised if something like that is swept up in part of what Students for Fair Admissions stands for, as Chief Justice John Roberts wrote, and that is eliminating racial discrimination means eliminating all of it. And the core purpose of the 14th Amendment's Equal Protection Clause is to remove all governmentally opposed distinctions on the basis of race. That certainly would, I think, be swept into there if you could show that what they're promoting on campus is some racially discriminatory program.
I think that's a really important point. That is the reach of SFFA. Somebody's got to find a way to say this easier, SFFA. You may recall, I think immediately after the decision was issued, the chair of the EEOC said, there's nothing to see here. These are not the droids you're looking for. This case has nothing to do. How many of these Campbell University students got that reference? This has nothing to do with employment. It has nothing to do with Title VII. And that's an overstatement, right? I think 13 state attorneys general on the other side says it has very much to do with employment. You can't have sweeping statements like the one Devon just quoted from the opinion and expect that employers are going to be immune from the implications of that decision. But there is a fairly vigorous debate going on now about how far SFFA will take us in the private sector. Fearless Fund helped us chart out that boundary a little bit more. And I think if you're an employment lawyer and you're not counseling your clients, that language from SFFA has significant repercussions for private sector conduct. I think you better go back and read the decision again.
Thank you very much.
Fortunately, we're out of time. We've got to move to our next item on the agenda. I'm not sure if the speakers will be available for the rest of the day if anybody else has any questions. But that was a very informative session. Please join me in thanking